When the courtroom went silent, something happened in a federal courtroom that almost never happens. Not a dramatic outburst, not a theatrical exchange, not a headline-grabbing stunt. It was quieter than that, and far more dangerous. A moment so stark, so severe, that even seasoned legal reporters, people who have spent decades watching judges reprimand defendants, recognized it instantly. This was different. A federal judge did not simply scold Donald Trump. She did not offer another warning. She did not issue a polite reminder about courtroom decorum or legal boundaries. She accused him, publicly on the record, of deliberate defiance, not misunderstanding, not confusion, not legal disagreement. Defiance. That word matters. Because in a courtroom, defiance is not about tone or attitude. It is about power. It is about whether the authority of the court still holds. When a federal judge uses phrases like flagrant disregard and contempt for the authority of this court, it signals that something fundamental has been breached. Federal judges are trained to speak with restraint. They are deliberate, measured, precise. They choose words the way surgeons choose instruments, carefully, intentionally, only when absolutely necessary. So when a judge raises her voice on the bench, when the temperature in the room visibly changes, when attorneys stop objecting and simply go silent, it is not theater. It is a warning. It means the legal system itself feels challenged. And that is exactly what happened here. For the first time in modern American history, a former president sat in open court while a federal judge made something unmistakably clear. Jail time was now on the table, not hypothetically, not rhetorically, but as a real, enforceable consequence. That moment did not arrive suddenly. It was a result of months of pressure building beneath the surface, pressure between judicial authority and a defendant who has spent years testing how far power can bend the rules. And in that courtroom, the bending stopped. The invisible backbone of the justice system. To understand why this moment matters so deeply, we need to be clear about something most people never think about. Court orders are not suggestions. They are not guidelines. They are not opening positions in a negotiation. They are the enforcement mechanism of the rule of law itself. Every trial, every hearing, every constitutional guarantee depends on one assumption, that when a court issues an order, it will be obeyed. If that assumption fails, everything else collapses. Trials become meaningless because evidence can be manipulated in public. Witnesses become targets because their identities are no longer protected. Juries become contaminated because narratives are shaped outside the courtroom. And courts lose the authority that makes justice possible in the first place. This is why judges take protective orders so seriously. For ordinary defendants, violating a protective order is one of the fastest ways to lose your freedom. Judges do not hesitate. They cannot afford to. Because once defendants believe court orders are optional, the legal process ceases to function. So when Donald Trump violated protective order, not subtly, not accidentally, not through legal ambiguity, but openly and publicly, the judge faced a decision that went far beyond one man. This was not about punishing a former president. It was about answering a much larger question. Does this court still have authority over someone this powerful? Or has status, influence, and a massive public platform created a category of defendant who can simply ignore the rules everyone else must follow? That is the question sitting beneath every word the judge spoke. And the answer she gave would reverberate far beyond that courtroom. Clear rules, signed acknowledgement. Early in this classified documents case, the judge issued a protective order. This was not unusual. In cases involving sensitive material, it is standard practice. But what mattered here was how careful the order was. It was precise. It was explicit. It was written in plain, unambiguous language. There was no legal jargon to hide behind, no vague phrasing, No room for creative interpretation. Trump was barred from naming or identifying witnesses, discussing evidence that had been placed under seal, sharing or describing classified materials, making public statements that could endanger individuals or taint the jury pool. This was not buried in footnotes. It was laid out clearly, line by line, and crucially, Trump's attorneys reviewed the order. They signed it. They acknowledged in writing that they understood it. There was no confusion about the rules. For weeks afterward, Trump did what he has done many times before. He tested the boundaries. He posted messages that skirted the edge of compliance. He used implication instead of direct reference. He flirted with violation without quite crossing the line. This was familiar behavior. Push just far enough to provoke a reaction. Pull back before consequences arrive. Assume restraint will always be rewarded with leniency until December 10th. That is when the pattern changed. Trump did not push the boundary. He smashed through it. In a series of posts, Trump did the very things a court had explicitly forbidden him from doing. He named a protected witness. He referenced sealed evidence. He amplified sensitive details to millions of followers. There was no subtlety, no plausible deniability, no ambiguity. Screenshots captured the posts. Timestamps recorded the exact moments they were published. The violations were preserved, archived, undeniable. At that moment, the case crossed a threshold. This was no longer about warnings. It was no longer about patience. It was about whether a court order meant what it said. And that question was about to be answered out loud on the record in a way no former president had ever experienced before. From boundary testing to open defiance, up until this point, the pattern had been familiar. Trump tested boundaries the way he always has, carefully, strategically, with just enough ambiguity to argue afterward that he hadn't technically crossed a line. He implied, he suggested, he hinted. That pattern allowed his lawyers to step in later and say, this was political speech, or this was general commentary. But December 10th was different. On that day, Trump didn't test the edges of the protective order. He stepped directly on its most explicit prohibitions. His post did three things, each independently serious, together explosive. First, he named a protected witness. This was not accidental. It wasn't a slip of the tongue. It wasn't a vague reference. It was a full name, published to millions of followers, in direct violation of court orders specifically designed to prevent that exact harm. Second, Trump discussed classified evidence that had been placed under seal. Again, not in abstract terms, not as a general complaint, but with descriptions that corresponded directly to materials prosecutors had explicitly identified as sealed. And third, he amplified those details to a massive audience, turning protected information into public spectacle. This matters because protective orders aren't about politeness. They're about consequences. Naming witnesses can lead to threats, harassment, or violence. Discussing sealed evidence can contaminate juries and compromise national security. Amplifying both multiplies the risk exponentially. Prosecutors did not speculate about what Trump meant. They did not infer intent. They did not rely on interpretation. They presented screenshots. They presented timestamps. They presented Trump's own words, unaltered, archived, undeniable. This was not a matter of opinion. It was arithmetic. Order issued, restrictions listed, posts published, violations matched. When prosecutors finished laying out, the picture was brutally clear. Trump had done the very things the court explicitly told him not to do. And once it became undeniable, the case moved from a debate about speech to a question of obedience. Could a defendant, any defendant, simply ignore a court order because he didn't like it? That question was now unavoidable when the judge stopped playing defense. The hearing itself began without fireworks. This is important. There was no immediate explosion, no raised voices, no dramatic confrontation. Prosecutors presented their motion. Trump's attorneys responded. They argued that the posts were political speech, that Trump had a First Amendment right to defend himself publicly, that the order should be interpreted narrowly. The judge listened. She asked clarifying questions. She took notes. She appeared calm, almost attached, and for a moment, it looked like this might end the way so many Trump-related hearings have ended before, with stern language, a warning, and another chance. Then the judge did something devastatingly simple. She stopped debating. She stopped interpreting. She put the protective order on the courtroom screen, and she read it, line by line, slowly, deliberately. Then she placed Trump's post next to it, not rhetorically, not symbolically, literally, where the order said, "shall not disclose the identity of witnesses." Trump's post displayed a name, where the order said, "shall not discuss sealed classified materials." Trump's post described them. The effect in the room was immediate. The courtroom went silent, not because of drama, but because denial had become impossible. There was no spin left, no argument left, no interpretation left. Everyone, lawyers, reporters, court staff, was looking at the same thing at the same time. Trump's lead attorney attempted to interject. The judge raised her hand. She wasn't finished. Then she addressed Trump directly. When this court issues an order, it is not a suggestion. That sentence landed like a hammer, because it wasn't just about Trump. It was about the idea, long tested, often indulged, that power can override law. She continued. A court order, she said, is not a guideline, not a starting point, not something to be interpreted creatively. It is a binding legal directive. Her tone had changed. Observers later noted that this was the moment the judge stopped managing defendant and started defending the institution. And when she finished, the room understood something fundamental had shifted. This was no longer about persuasion. It was about authority, the nuclear option. Then came the ruling. The judge held Donald Trump in contempt of court, not rhetorically, not informally, formally, on the record. She identified 5 separate violations. She fined him $50,000 for each one, a total of $250,000. But everyone in the room understood immediately. The money was not the point. For a defendant of Trump's means, fines are noise. The real moment came next. The judge looked forward and said that any further violation of protective order would result in custodial sanctions. That phrase is not dramatic. It is clinical, and it means jail, not symbolic detention, not theoretical consequences, actual custody. This was the first time a judge removed all ambiguity. No more warnings, no more benefit of the doubt, no more assumption that status would shield the defendant from the ultimate sanction. The judge explained her reasoning carefully. She had been patient. She had tailored the order to Trump's position. She had tolerated weeks of boundary testing. But this violation, she said, was intentional, clear, and dangerous. It endangered witnesses. It threatened the integrity of proceedings. And it showed contempt not just for the order, but for the court itself. At that point, the message was unmistakable. The rules apply here, to everyone, even to a former president. And for the first time in modern American history, the legal system had placed a former commander-in-chief on explicit notice. Defiance now carries consequences that cannot be waved away. This didn't come out of nowhere. What happened in that courtroom did not emerge in a vacuum. It was not an isolated lapse. It was not a one-off mistake. It was not a misunderstanding that spiraled out of control. It was the latest chapter in a long, well-documented pattern, across multiple jurisdictions, across multiple judges, Across multiple types of cases, the behavior has been remarkably consistent. In New York, Trump repeatedly violated gag orders by attacking the judge's family, and court staff. He posted about a judge's daughter. He shared photos of court employees. Each time, the court responded with fines. Each time, Trump paid them. And each time, the behavior continued. In the January 6th case, a gag order was imposed after Trump attacked prosecutors and potential witnesses. The court warned him. His attorneys appealed. Some language was modified, but the core restriction remained. And Trump continued to test it again and again, forcing repeated judicial intervention. In the civil fraud trial, Trump attacked the judge's law clerk by name, posted her photo, and making false claims about her political affiliations. The response was swift: sanctions, fines, stricter gag orders. And still, the behavior edged forward. The pattern is unmistakable. First, push the boundary. Second, absorb the fine. Third, assume escalation will never come. For years, that assumption held. The ultimate sanction, custody, was never imposed. And over time, that absence of escalation created a dangerous belief that jail was a theoretical threat, not a real one. This judge shattered that belief by explicitly warning that further violations would result in custodial sanctions. She did something no other judge had done so clearly. She said, in effect, the pattern stops here. This wasn't about punishing past conduct. It was about ending the cycle. And by doing so, she reframed Trump's entire legal posture, not as a defendant who occasionally pushes too far, but as one who repeatedly treats court authority as optional. That reframing matters, because courts don't respond to isolated mistakes the same way they respond to persistent defiance. And this ruling made clear that the court now views Trump's conduct through the lens of pattern, not incident. Why this changes everything. This ruling does not simply affect one case. It alters the legal landscape in three profound ways. First, it sets precedent. For years, judges overseeing Trump-related cases have faced an unspoken dilemma. No one wanted to be the first to jail a former president. The political implications were enormous. The risk of backlash was real. This ruling changes that dynamic. Now, any judge confronting similar conduct can point to this case and say, I am not escalating. I am following precedent. That matters in law. Second, it destroys appeal narratives. Trump's legal strategy has often relied on ambiguity, arguing that orders were unclear, restrictions were overbroad, or intent was misinterpreted. Here, there is no ambiguity. The protective order is explicit. The posts are documented. The violations are undeniable. Appeals courts do not reweigh facts. They examine whether a judge abused discretion. And when the record is as clear, discretion is firmly on the judge's side. This ruling will follow Trump into every future hearing, every motion, every argument that asks the court to trust him. And that trust has now been formally withdrawn. Third, and most importantly, it restores court authority. This ruling sends a message that has been dangerously close to disappearing from public life. Power does not cancel consequence. Court orders are not optional. Status is not immunity. Influence is not exemption. The judiciary asserted something fundamental, that the rule of law applies not just upward in theory, but downward in practice. That is not a small thing. That is a system reminding everyone that it still has teeth. Martyrdom versus accountability. The legal consequences are severe. The political consequences may be even more complicated. Trump now faces a dilemma with no clean escape. If he complies, if he goes silent, restrains himself, stops commenting on the case, he undermines a defiant persona that fuels his political brand. Silence looks like submission. Restraint looks like weakness to his base. But if he continues to defy the court, the cost is no longer financial. It is incarceration, and that risk is real. Inside Trump's political orbit, the reaction has fractured. Some advisors are urging discipline. They see jails politically catastrophic, not heroic, not galvanizing, but destabilizing. They fear images of a former president in custody would alienate moderates and shatter any remaining claim of control. Others argue the opposite. They believe escalation is the point. That jail would turn Trump into a martyr. That defiance is not a liability, but the core of the movement itself. This is not just legal strategy. It is a stress test of democratic legitimacy, because the question underneath the political debate is stark. Will accountability be accepted as lawful consequence or rejected as persecution? How the public answers that question will shape not just this case, but the future relationship between political power and legal restraint. Does the law still mean what it says? Strip away the personalities. Strip away the politics. Strip away the spectacle. What remains is a single question. Can the legal system enforce its own rules against the most powerful? That is the question this moment forces us to confront. A judge has drawn a line, not rhetorically, not symbolically, but with consequences attached. What happens next will tell us everything. If the line is crossed without consequence, then the rule of law becomes performance. Language without force, authority without enforcement. But if it is enforced, then this moment will be remembered not for who stood in the defendant's chair, but for what the system chose to defend. Because the rule of law does not announce itself loudly. It reveals itself quietly in moments when power is told no and the answer holds. And in that courtroom, for the first time in a very long time, the system spoke clearly enough